Staff, Attorney Quinton Docs, and number 79657. What my client, Mr. Sean Glover.
Morning. Your name?
Deshaun Glover.
All right. What are we doing today?
Your Honor, I am going to ask for another PCC. I know I didn't fill out this.
He didn't fill out the form.
I didn't fill out
He
the
was just
form.
gonna march up here.
And I was told
He was
to-
just gonna march up here and just do it. And I'm supposed to just not. He marched up, he came up, he said, I'm not following that rule. I don't care what that judge says. He was saying all that. I could hear it. All the way up here saying that. And then
Your Honor, I would like to address bond.
how much time did you need, counsel?
Your Honor, I would just need a short adjournment, 2 weeks.
Sure,
is fine.
2 weeks, all right. Probable cause conference will be adjourned December 5th, 2024, 9 a.m. Yes, as to bound.
Yeah, Your Honor, as to bond, Your Honor, I spoke with his mom. They have retained counsel. Obviously, you know the requirements. He's not going to be a flight risk, Your Honor. This is my client works with his uncle. I can verify the company. He does landscaping. They're doing snow removal right now, and we're asking for a lower bond, Your Honor. If we can even do house arrest, that's fine for right now for my client.
Response from the people.
It's threefold. One out of Taylor for $400, one out of Clint for $3,000, and one out of Genesee for $500. He has 2 prior convictions for fleeing third, one from 2010, one from 2015, a prior conviction for R&O. Beyond that, the nature of this case is concerning in and of itself. The charging ETA on this actually requested a $500,000 cash security for $150,000. In this particular case, the defendant went to the Comfort Inn to have sex with the victim. The defendant and the victim got into an argument, after which the defendant chased the victim with his car and almost ran her over. Law enforcement arrived on scene and observed the defendant's vehicle and observed the victim exit the vehicle and enter the hotel. On contact with law enforcement, the defendant admitted to chasing the victim in the parking lot, but denied hitting her. When the law enforcement contacted the victim, she was visibly distraught and expressed fear of speaking out against the defendant because of potential retaliation concerns. The victim advised that she previously tried to leave the defendant, but he wrecked his car, and when she tried to get her own apartment, the defendant showed up with a baseball bat and began breaking things. And then after he was breaking things, he said, "Are you still leaving?" The victim also advised that the defendant has quote unquote people who will hurt her if she speaks out against the defendant. I mean, at this point, I'm significantly concerned. I think on to lower than we originally asked for. I understand it's high, but I don't think reduction is appropriate.
Your Honor, as an officer of the court, I think the victim,
Pardon?
she has called me 2-3 times, and they were in a relationship, dating relationship, Your Honor. So that was his girlfriend, and it still is his girlfriend. So I'm not exactly sure what the nature of the victim and what the sister counsel is referring to, but that is my client's girlfriend. They've been in a relationship for a couple of years, Your Honor, and she has called me as recently as today, as to try to advocate for my client.
I think given the statements that she made to law enforcement, it's pretty clear potentially why she would be motivated to do that if she has concerns about retaliation, if she were to participate or do anything other than advocate for the defendant. So I don't think that a release would necessarily be advantageous for anyone.
And Your Honor, if I may, we can ask.
Yeah, go ahead.
I want to put in quotation marks, victim. She was willing to come to court today. I just advised not to, just as a air of impropriety, but she can appear in court, and obviously she can tell you freely what her intentions and fear of repercussions are in person.
Well, I guess I hear what you're saying, counsel, but I guess it could happen. I'm trying to reconcile count 2 as charged with the statement of the relationship of the parties.
And how long have you been dating?
For nearly 2 years now, sir. Okay, but I guess what I'm getting at is that charge count two is the transportation of a person across state lines to assist in prostitution. And that individual named it.
Yeah, and that's, we are miffed with that.
Pardon?
That we're confused why that was charged, and for the nature, it has nothing to do with any of the police report had anything to do with prostitution or anything like that. Even the victim herself didn't state that she was there to do that. We were just confused and surprised, Your Honor, by that. And obviously talking with her, that she's mentioned to me several times with her talking with her mom, his mom, she's called me several times. I said this morning, and took his car when the incident happened, drove it back to Flint, Your Honor. So this is not what that police report alleges.
Well, I'm okay. Then I'm going to need some further clarification
Okay.
on that before I do anything regarding bond on this. So at this juncture, I'm going to deny the request for.
And I'll have her in 2 weeks, Your Honor, have her here. Thank you.
Thank you. She's back.
Good morning, Your Honor. Hannah Mackey appearing on behalf of Mr. Wade, who's appearing to my right. Mr. Wade, please state your name for the record.
Beyond Wade.
All right, he's waiving exam.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of information, waive formal reading, and my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set before
December 3rd at 1:30 p.m. with Judge Confronts.
December 3rd, 2024, 1:30.
Thank you. Your Honor, may I quickly address bond?
Why not? Everybody else says yes.
Pardon?
Yes.
Oh, thank you. Your Honor, in this case, bond is set for $10,000 with 10% bond, for which Mr. Wade can't afford. The client does advise that he has a bed at Delonis Center and he is willing to do a GPS tether. He's not intending on going anywhere as he had just started his probation and he is seeking employment. On this matter, probation has given him 2 PR bonds on the circuit court matters, which should speak to their assessment of flight risk and danger to the
Who
community.
is giving him that?
The circuit court. On the circuit court matters, he was given by probation 2 PR bonds.
Was he?
He was.
Oh,
And that should speak to
that should say what to me?
that they think that he would not be a flight risk,
Really?
yes, or a danger to the community.
Oh. When did he get those PRs?
In circuit court,
You don't know when?
I do not.
That'd be a no. So why is he locked up then? There anything unfair as to my questions? Why is he locked up on this case? If he has PRs on the circuit court matters, why is he in custody?
Your Honor, I believe,
Crickets.
Your Honor, I believe that there was a violation incident because of these charges in the circuit court. They let him out on PR. As a result of this pending matter, we're asking for his release on this case as a result of that. And he was
What?
he got probation violations as a result of this charge, Your Honor. The circuit court gave him PRs on their matters.
On the violations?
On the violation.
Is that the people's understanding?
I don't know, I'm trying to get through his 26-page criminal history, but if I'm understanding correctly, he will have $1,000 of this. He's asked just for an in-custody date so we can get all the matters before Judge Kunke, and I don't think a PR bond is appropriate. The allegations in this case are that the defendant was masturbating in front of a female correctional officer. officer. So if he's certainly willing to do that in custody, I do believe that he could be a danger to the community if he's out of custody. And if he doesn't have anywhere to live, I don't know.
Your Honor, he has a bed at Delonis Center, if I may. And he is willing to do GPS tether.
Well, he has a bed there?
Yes.
You can, as long as it's not home confinement.
Well, I understand that, but so when this, so why was he in custody
Before this
to
happened.
even be able to commit this offense?
Is it my understanding, Mr. Word, that you were waiting on getting a PSI done?
This case is from February when I was locked up.
And you were locked up in February because of the cases that are before the circuit court now?
Because of the cases that was PR bond to me.
Because what?
Because
Yes.
of the cases that
Yes.
was PR bond.
The circuit court matters, Your Honor.
So these offenses he committed while on
While I was in.
bond, but while he was incarcerated on another case.
Yeah. And they didn't charge me with it until I just recently
Thank
got locked up.
And Your Honor, he was arraigned on October 28th before Judge Slay. He had the hearing before Judge Conkey, who then gave him a PR, and that was on the date of 10/31. So he's had a PR on those matters. It's just in on this.
Well, I'll tell you what, he's gonna be up before. I don't think it's appropriate to let him out on a PR given the circumstances, but I'm sure Judge Conkey may feel differently having given him PR on the probation violation. So I'm gonna deny the request at this time, and you can take it up with Judge Conkey.
Okay.
Bond
Your
will
Honor.
continue.
We are set this morning for probable cause conference. The people are going to be filing a nollie in this case. I expect it'll be to the court before the end of the week.
All right. Any objection?
No objection.
This case is dismissed.
Thank you, Your Honor.
All right. Thank you.
Thank you.
Thank you, sir.
Honorable Judge, so the case is dismissed?
Yes.
Yeah, well, that's what I ordered. You want me to do something different?
No. I just got one question, sir. I've been in here 38 days past my ERD. I would like to know how many business days will it take for y'all to fax the information over to the prison?
To get it over to where?
How to fax the final disposition today of the case being dismissed? How many business days will it take for y'all to fax it to the prison so I can be released? Because I'm past my ERD.
Gotcha.
And this is the only reason.
Okay.
Yeah.
So when can we get a nollie pross down today?
I think it's very likely.
Okay. Thank you for letting us know that. They're gonna get the nollie pross down to me. I'll sign off on it. It'll be in the file. Now, how it gets to anybody, I don't know. But
Okay.
we'll do what we need to do on our end.
Thank you so much, Judge Simpson. It's good to see you. I watch you on court cam all the time.
Thank you, sir.